Hi there, welcome back to the last topic in Module 1, Topic 5. And in this topic, we're really going to start examining the relevant planning legislation in Queensland. And our first topic for today, in this topic, our first issue is the question of ecological sustainability, which is in fact the statutory purpose for planning in both the Sustainable Planning Act and the New Planning Act. Okay, so here you go. This is from the SPA. The purpose of this Act is to seek to achieve ecological sustainability. So in this topic, I'm going to examine what that actually involves in a little bit more detail and raise some questions for you about, does it make a difference having a statutory purpose? Do we know what planning is all about in Queensland? Is there this consensus that we wish to achieve ecological sustainability? It sounds very green, doesn't it? So it sounds a bit promising if you're a bit of a greenie. Okay, what does it actually mean? Here's a definition of ecological sustainability. It's the same between the SPA and the PA, which is the Planning Act 2016. And the SPA, of course, is the Sustainable Planning Act, I should say. Ecological sustainability, the overarching objective of the Act, is defined in this way. Ecological sustainability is a balance that integrates protection of ecological processes and natural systems at local, regional, state and wider levels. So an ecological focus and economic development and maintenance of the cultural, economic and physical and social well-being of peoples and communities. So those are the parts of the legislation, if you want to look them up, where I've taken that from. It's a very holistic, comprehensive definition, isn't it? You can see it's the triple bottom line: economy, community and ecology or environment. It's actually different to another definition which you'll see in other legislation and is derived from the NSESD, which is the National Strategy for Ecologically Sustainable Development, a bit of a mouthful, 1992. In that definition of ESD, we find that that means using, conserving and enhancing the community's resources so that ecological resources on which life depends are maintained and the total quality of life now and in the future can be increased. So there's much more of a kind of ecological emphasis in this one, perhaps even we could say a bottom line that, you know, whatever you do, you should be maintaining the stock of ecological resources for future generations to improve the total quality of life. You don't get that feeling from looking at what's gone into the SPA or the IPA, and that's for a reason, or the Planning Act I should say. That's for a reason because the drafters felt that, you know, urban planning or planning and development, land use development control was had to be cognizant of more than just environmental protection. It already exists within a framework where we must promote economic development, as we've seen in previous topics, and of course we're sensitive to cultural, economic and physical and social well-being because land is a shared resource to some extent, certainly a scarce resource. So they felt that they would have their own interpretation of ESD that was more appropriate to land use planning. Okay, not only that, they also give us, you remember the statutory objective is to promote and encourage ecological sustainability. Okay, to seek to achieve ecological sustainability. Interestingly, not just a definition of ecological sustainability in both pieces of legislation, but also a description of how this Act functions to achieve ecological sustainability. So it's by managing the process by which development takes place, encouraging an accountable, effective and efficient outcomes with respect to planning and land use decision making, managing the effects of development on the environment, including managing the use of premises, what the impacts will be, continuing the coordination and integration of planning at the local, regional, state levels. So those were really big objectives in the IPA and the SPA, and they've kind of been incorporated into this idea that, you know, this is what the legislation's all about, and that's how you'll seek to achieve ecological sustainability, not just, please note, by protecting the environment. You can see nothing too much has changed in the New Planning Act, where we're looking at Section 3 there. The purpose of this act is to establish an efficient, effective, transparent, integrated, coordinated and accountable system, just like we've got, over on in SPA Section 3, subsection A. System of land use planning, development assessment, related matters, facilitates the achievement of ecological sustainability. So we've gone from seeks to achieve to facilitate the achievement. All very aspirational. Okay, we didn't have to go with this idea of balancing the triple bottom line of economy, environment and community. As you can see, at about the same time as the IPA was originally being prepared, the Resource Management Act in New Zealand, which is their chief Land Use Planning and Development Control Act, was introduced. And look at the definition here. Their bottom line, or their statutory objective, is sustainable management, which means managing the use, development and protection of natural and physical resources in a way or at a rate which enables peoples and communities to provide for their social, economic and cultural well-being. So it's still got all those aspects in economy, society, culture and community, and for their health and safety. But the trick is here, the tie is it's while, or subject to is the appropriate interpretation, sustaining the potential of natural and physical resources to meet the reasonably foreseeable needs of future generations, safeguarding the life-supporting capacity, avoiding, remedying or mitigating any adverse effects on the environment. Now, some of you might feel, much the same, all just written out in a different way. I actually think that they've put the environment first. They haven't said it's balancing between equally weighted factors. They've said the environment comes first and all the other things can occur subject to protecting your environment there. So that's an alternative way of going about it. The reason that they did that in New Zealand was because they were a bit unhappy about this idea that you must always be balancing your economy, community and environment. They said that doesn't always work out well. And the problem they identified, and perhaps we can make this comment or critique about what's in the SPA or the Planning Act. The problem with such a prescription, the balance that integrates idea, as we have in Queensland, is that it requires the kind of directive and controlling approach to economic and social activity that must inevitably focus on trade-offs reached in a judicative euphoria. I love that phrase. Many still feel comfortable with that approach, usually on the grounds that their view of needs and opportunities will win out on the day. So let the judge decide. In truth, it is an approach to resource use that is fraught with uncertainties for developers and environmentalists alike. So that was the reason why they attempted, debatable how successfully, but they attempted to move a little bit away from just balancing all these different factors in a fairly discretionary way. But you could argue we've gone exactly the opposite way and made it more and more about balancing with a high level of discretion. Okay. Now we are focusing in this topic on ecological sustainability and what that actually means to have a fundamental objective for the legislation, because it's stated right up there in section 3 and then it's a little bit lost actually throughout all the remaining 700 or whatever pages it is. Okay, well, there are a few sections that come up also early in the Act though to guide us. If under this Act a functional power is conferred on an entity, the entity must perform the function or exercise the power in a way that advances this Act's purpose. Or there are some little exceptions and provisos there which I actually can't read. I've put them so small. The reason why I've put them so small is because we've moved on now in the Planning Act to a statement that, whoops, let me go back here. An entity that performs a function under the Act must perform the function in a way that advances the purpose of the Act. So you must be able to justify your decision as advancing the purpose of the Act, which is to facilitate ecological sustainability. So in actual fact, looking at these sections, this is a fairly onerous and real and concrete obligation. And just before we move on to have a look at a couple of cases, we're even given guidance following section 4 in section 5 on how to go about advancing ESD. So, you know, they have tried to be helpful here. Again, all still up at the front of the legislation. Your ESD decision making will look accountable, coordinated, effective and efficient. I'm not sure what that's got to do with protecting the environment. It will take account of short and long term, but then ESD was much more than looking after the environment. It will take account of short and long term environmental effects, apply the precautionary principle. In the readings, you've got a definition of exactly what the precautionary principle is, so you might want to write it down for yourselves. Seek to provide for equity between present and future generations. Apply standards of amenity, conservation, energy, health and safety in the built environment. Provide opportunities for community involvement in decision making. That's not quite all of them, but it's a taste, a sample of the things that are covered in Section 5. They're also, many of them are also included in Section 3 now of the Planning Act. Okay, so we've got a statement that we should seek to achieve or seek to advance ecological sustainability. We have a definition of ecological sustainability, that it means balancing and integrating the triple bottom line. We have an obligation imposed on decision makers to advance or seek to achieve the statutory objective of ecological sustainability, and we have some guidance on how you can go about advancing ESD in the legislation. So, like I say, you might think that's a lot, but it's only these key sections at the start of the legislation. What have the courts done with these prescriptions to them? Okay, there's a whole range of what you do when you have an objects section in a piece of legislation, and they've been discussed in the context of the SPA. So the first one, and perhaps the minimalist approach to this definition or this objective of seeking ecological sustainability, is to say, well, really, you are just describing what this act is about. It's very multi-pronged. I weighed up all those considerations in the past, and really nothing much has changed. It's so huge and ubiquitous that we can't really, I can't make it, I'll just continue in the same way. And a case example there is Elliott and Brisbane City Council. It's a while ago, I haven't got the details. You can read more about these cases in the text that I've set for you. Okay, so nothing too much has changed because I still have to balance up and consider everything, just like I do in any planning case, would be a summary of that first viewpoint. In a slightly more radical or proactive response to being told that your acts and your decisions must advance ecological sustainability, we see other cases in which they say, well, that's got to guide me in cases of uncertainty. And in the Yannicka case, the judge stepped out and said, well, the applicant had failed to give adequate public notification on a development application. Could that be excused as just a minor procedural error? The judge said, no, community consultation is really important because it's prioritised. It's stated in Section 5 of the SPA. So it's an aspect of ecological sustainability which drives and is assisting me to interpret the requirements in the Act. So it's an aid to statutory interpretation. I must give it weight. If in doubt, go with the decision that favours an approach to advancing ecological sustainability, an interpretation which is entirely consistent with the Act's Interpretation Act for you law students among you. Okay, there's still some alternative way to look at this. There's a list of specific statutory considerations when relevant. Do you remember I suggested that there are a list of specific things that we're shown. These will advance ecological sustainability. For example, allowing for community participation. Remember use of the precautionary principle, where there's an element of scientific uncertainty. You must at least be precautious and set conditions to prevent the risk of environmental harm. That's exactly what the courts picked up on in Yamuchi case, where they actually refused a development application for an intensive piggery because there was too much scientific uncertainty about the impact on odours to neighbouring properties. So that was a precautionary approach as endorsed and condoned by the early sections of the legislation, saying this will advance ecological sustainability. The last one, and perhaps the most creative, is the idea of an independent test of legal validity. And perhaps best to talk about an example for you here. In the Chesil case, which I've set as required reading, so we will talk about this a little bit more in workshops. In the Chesil case, local council had refused an application to develop townhouses for retirement living on a sports ground at John Paul College, which actually backed onto the Daisy Hill Koala Conservation Area. The developer had a block of land that included this former sports ground. It must have been sold on, but it also included a large amount of native bush that was actually abutting onto the conservation area. So the developer's argument was that by developing this small area, the existing disused sports ground, for a nice townhouse type retirement living project, in return for that prerogative, he would reserve and create a conservation zone of the rest of his land, which was already bushy. Previous developments had suggested that that didn't have to be the case. He was throwing it into the bargaining process. Council, however, refused his application because they said in their planning instruments this was part of a, can't quite remember, but it was a conservation zone of type, and it was not for urban development. So under the future regional plan, under their existing planning documents, this was not zoned for residential developments. They didn't want to change it. They had their instrumental position and that was what they were sticking to. So the developer was unhappy with his refusal and approached the Planning and Environment Court. The Planning and Environment Court said, yes, there is conflict with the relevant planning instruments, but there's this proviso in the law that if you have sufficient planning grounds or sufficient grounds, if you can make out a really strong case, I might let you go ahead anyway, despite the conflict with your planning instruments. And so the developer said, well, I have got a really strong case because I'm promoting ecologically sustainable development. I'm promoting conservation in the area that is woody vegetation and actually backs onto the conservation reserve. I'm promoting economic development, providing for a growing proportion of the population that's aging and wants nice, quiet retirement living. And I'm providing a sense of community within that development as well. So he argued that I've got the perfect balance of ecological sustainability. So and the court finally took the same view. There you go, here's an example. Here's the quote. The proposal is consistent with the purpose of the Act. The submission was in fact that it would provide economic development of a kind which would assist in meeting the needs of the community and provide for its social well-being without adverse effect on the well-being of communities, people or communities otherwise, it was vacant land, while at the same time protecting ecological processes. I agree. So even though on its face, this decision or this application purported to put residential development adjacent to a conservation zone in an area that was not scheduled or not planned or zoned for urban development of any kind, and even though it was against the wishes of the council, this development was allowed to go ahead. It really was a negotiated, well, I mean, eventually it went before the court, but it really was a balance struck, wasn't it, between the multifaceted aspects of ecological sustainability. So that was going back to first principles. Have a read of the extract that I've set as required reading. It says, I'm going back to first principles here. I'm testing whether this is a really good application that fits in with the objective of ecological sustainability. So that is by far and away the most creative use of the statutory purpose sections in Queensland. Now, just before we finish, I've got, I think, 2 more slides. I want to give you notice that, you know, we might think Chesil was a controversial or an ambitious case. In New South Wales, the judges in the Land and Environment Court really get involved in this ecological sustainability debate. I think that's fair to say. There's been some really active proponents of that. We won't be looking at them very much in this case, but I'll just draw your attention to one case, which was Gray and the Minister for Planning in 2006. This was a judicial review of a development application which was to actually extend a mine, so really land use on a huge scale here, the Anvil Hill mine. There was an environmental impact assessment prepared under state legislation, but in that EI statement, the environmental impact statement, the developer had not disclosed the amount of coal that would be burnt, whether in this country or overseas, and it would probably be overseas, and the contribution that would make to climate change and greenhouse gas emissions. They would be significant if he had disclosed it. But it was the view of the developer, well, I'm not doing that. The people down the road, when I sell it, might do that, but my development is to dig up coal, and there will be minimal, there will be some, but not too extensive greenhouse gas emissions in that process. So the minister took the EIS and approved the development to go ahead. Objectors, and this was peculiar to New South Wales, were able to stall the development in court by arguing that that was an insufficient administrative process because they'd failed to take into account a relevant consideration, the climate change issue. Just look what they say about ecological sustainability, or ESD principles, in that jurisdiction. Numerous decisions of this court have confirmed the importance of ESD principles for decision makers. It is not merely a political aspiration, not a mealy-mouthed manifesto, but must be applied when decisions are being made under the Water Act and any other act where it's mentioned. They also said, taking it at its very broadest principled approach, it's apparent there is a failure to take the principle of intergenerational equity into account by requirement for a detailed GHG emission assessment in the EAR. If the major component of GHG, this is greenhouse gas emissions, which results, that is scope 3 emissions, these are the ones overseas, is not required to be assessed. That is, there is a failure of a legal requirement to take into account the principle of intergenerational equity. So, we have some good solid legislation in Queensland on this matter. It's much more balanced, and it has to be by virtue of the definition of ecological sustainability. You can see there's really quite a slightly more rebellious approach, you could say, in some of the case law emanating from New South Wales, where they said it really is a legal requirement to take into account the precautionary principle and intergenerational equity and all those detailed aspects of ESD. Okay, that's enough from me for Module 1. Just a review and reflection on where we've come across the whole topics that I've discussed with you in Module 1. We've looked at the nature of planning and planning law in particular. I've given you a brief overview of planning law in Australia. We've looked at the background to the SPA and the newer Planning Act, and we've considered this overall statutory objective of seeking to achieve ecological sustainability, and does it really make a difference? So thank you.